Hi, y'all, and welcome to tonight's live stream. I have been told that for the first 10 seconds, YouTube isn't broadcasting and people are having a hard time hearing the signature tagline found only on the Lawyerly channel. So I'll say it a second time for those of you just coming in. Hi, y'all, and welcome to tonight's live stream. Before the trial of Karen Read's team pushed to present third-party evidence, third-party culprit evidence, it's called, about two particular people, Colin Albert and Brian Higgins. But did it work out the way they thought it would? What evidence was actually presented at trial about Colin Albert and Brian Higgins? And what is third-party culprit evidence anyway? We're going to dedicate tonight to Mama Pinks, who asked me early on, said, what is third-party culprit evidence? And I haven't had time to get to it. So we are going to cover it tonight, and we're going to look specifically at what was said about Colin Albert. And we're going to ask the question, was it sufficient? Was it enough? Does it fit? And so those are the things we're going to be talking about tonight. Now, I am not going to be making a grand statement about whether I think Colin Albert or Brian Higgins actually murdered John O'Keefe. My goal is just to gather the evidence and to explain what third-party culprit even means. Like, what does that mean? And what was the actual evidence? And then, of course, you can figure out for yourself what your opinion is about whether or not this worked. I am going to point out something very important, I think, which is that the defense did not mention Colin Albert even once during closing argument. It was a pretty stark contrast to the way they treated Brian Higgins, because they talked a great deal about Brian Higgins in the closing. So I think that's significant. It's a really big difference. And so I want to point that out from the beginning, and you can kind of consider that as we look at what the evidence was. So hit the subscribe button. Tomorrow night, we're going to be covering Brian Higgins, and you don't want to miss that one. If you would also hit the like button on the video, it'll help it get out to more people. So there are four things we're going to cover tonight. The first, I want to talk about just what is third-party culprit? What is the law? What does that even mean? The second is I want to cover some of the testimony about Colin Albert. The third thing I want to cover about is what was said, or in this case, not said in closing argument. And the fourth is I want to kind of pull it all together with a timeline. So that's how we're going to kind of structure the talk tonight. So I want to say a shout out and a special hello to the first five who were in the chat tonight. And that's the first five who weren't in yesterday. I'm trying to spread the love around by picking more people. So Melody Perkins, Ellie Sue, Suzanne, Becca Hill, and Chris Ganga. Welcome to everybody and to the five of you. All right. Now, when I talk about in the thumbnail or in the description to the video, when I talk about Karen Read's case against Colin Albert, I'm not talking, it's real important to note the difference. I'm not talking about a legal case. Nothing about what happened here means that Colin Albert would be charged with a crime or that Brian Higgins would be charged with a crime. I just mean in the sense of gathering evidence, like state your case, make your case in that sort of sense. So let's take a look at what the law is. Let me add to the stage. Massachusetts Rule of Evidence 1105. So evidence that a third party committed the crimes charged against the defendant. So in other words, someone else did the crime you are charged with if you're the defendant. So someone else did the crime Karen Read was charged with, or had the motive, intent, and opportunity, all three, to commit the crimes is admissible, provided that the evidence has substantial probative value. So if evidence that the person actually committed the crime or had motive, intent, and opportunity to do it is admissible, that means it can come in at trial if the evidence has substantial probative value. That means it has to actually take the case somewhere. It has to really actually be significant enough that it's not just an accusation, it's something substantial. In making this determination, the court must make a preliminary finding. That means she's going to have to make some statements or written statements that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. So those are the three things she's going to have to find. Is this relevant? Does it really fit with this case? Is it remote, speculative, doesn't really, it's like way off in the distance, maybe, possibly, but not really tangibly connected. And then the third thing is it going to prejudice or confuse the jury? So that's what the court is going to be looking at. And the court's going to be doing a balancing act here. Let me go ahead and switch that around. The court's going to be doing kind of a balancing act because on the one hand, the defendant has a right to defend herself. On the other hand, you don't want to accuse people of crimes. You don't want to just talk about things that they did in the courtroom for no reason. People who aren't even accused of this particular crime, at least not by the authorities. So it's kind of this balancing act. Let me take you to the notes on the rule and show you what additional notes are said. Third-party culprit evidence that someone else committed the crime charged or had the motive, intent, and opportunity to do so is a time-honored method of defending against a criminal charge. So for a long time, people have been pointing at other people saying, I didn't do it. It was Jane. It was Joe. Think of Perry Mason. It was always someone other than the person he was representing, right? So a defendant possesses a fundamental due process right to present such evidence. So the defendant has the right to present to the jury the idea that Jane did it or Joe did it, someone other than the defendant. That's a due process right. The erroneous exclusion of such evidence upon proper objection requires reversal unless harmless beyond a reasonable doubt. What that means is the tie is going to go to the runner. In other words, if it's close, then the judge is going to have to allow the evidence in, because if you exclude it, and you should not have as a judge, it's going to, quote, require reversal. That's really strong, unless it's just harmless beyond a reasonable doubt. So the judge has to be pretty sure if it's going to be excluded. The judge has to look very carefully at that and does not want to err on the side of excluding it. That would be too risky. So then the last page of the notes, the evidence must be relevant, that is, must have a rational tendency to prove the issue raised by the defense and cannot be too remote or speculative. And evidence of a third party's ill will or possible motive to commit the charged crime standing alone is insufficient to qualify as third-party culprit evidence. The evidence must also show that the alleged third-party culprit had the intent and opportunity to commit the crime. And so that's what we're going to be looking at tonight. The judge will be reevaluating everything when it comes time for trial number 2. So the judge will be looking at this. Probably there will be a motion or argument that this shouldn't be included, and she'll have to make calls like this. Did the evidence suggest that Colin Albert had the intent and opportunity to commit the crime? Was he even present? Because the prosecution says he wasn't around. He wasn't there. He could not conceivably have committed it, even if he had the motive, and he had no motive. So we're going to get into that. We're going to look at what the actual testimony was. And so now let's turn to part 2 of tonight. We're going to talk about the testimony. Now, I have cut this a ton just to make it shorter, and I've got just a few clips because I want you to have sort of an understanding just in general of what was said about Colin Albert at trial, what was presented. So let's start with the issue of when he got home. When exactly did Colin Albert get home? Remember that he had been over at 34 Fairview visiting his cousin, Brian Albert Jr., and he'd been over there. It was Brian Albert Jr.'s birthday the very next day, and he was over there helping to celebrate, just dropping by to say hello to his cousin. He got home. The exact time that he got home is somewhat in dispute. So I wanted to play for you what some of the people at trial said about when he got home. Specifically, I want to play for you what his mother and father said, because they say he came in and talked to them. So here's what was said. Now, the witnesses in general said that Colin Albert did not overlap with John O'Keefe at the party, or certainly not by much. So let's walk through it. This is Colin's parents. We're going to start with Brian, who say they saw him roughly at about 12:30, that he came into their room.
Actually, you came in, went to bed, so do you know what time your son came home that night?
Yes.
And how do you know that, sir?
Because he opened the bedroom door and said, "Good night, guys. I love you. I'm home."
And about how long after you got home was it that your son got home?
I'd say within 10 minutes.
And as far as sort of coming into your room, is that something that was required of your kids when they came home?
He would always do that, yeah. That was something just to let us know that they were home.
And
now
about
Julie.
how long was it after your husband came home that your son called?
10 to 15 minutes.
And were you essentially waiting up for him?
Oh, yes. Yep.
Is that sort of common practice?
Yes, I do not go to bed until my kids are home.
And is there another common practice as far as when your kids come home, where do they go when they first come in?
They immediately will always come in the door, maybe grab a water out of the fridge and come upstairs and give me a kiss goodnight and tell me that they're home.
Now, did that happen on this occasion?
Yes.
And so Colin came into your room at some point?
Yep, he came right upstairs. Yes.
And when Colin came into your room and he came upstairs, did you have occasion to observe him as far as talk to him, obviously?
Yes, we talked for a minute. He asked me if I was feeling better. And yeah, we talked for a moment.
And during that conversation that you had with Colin, similar to what I had asked you with regard to Mr. O'Keefe, what, if any, injuries or anything did you observe on your son Colin?
None.
I went up to the bedroom.
So let me stop it there. And so the defense had several approaches to sort of undermining or tearing apart this testimony, because the testimony from his parents was, we saw him at home, he had no injuries, and we saw him at home before John O'Keefe even arrived at the party, according to the prosecution, but definitely he would have had to leave the party in time to get home around 12:30. So one of the defense approaches was, one of Karen Reed's team's approach was to say the time that Colin Albert got in was really later than his parents said. They're really just protecting him. And here's kind of how that played out in testimony.
All right.
Took off my clothes, jumped in bed.
All right. Do you have a master bath with regard to your bedroom?
There's a bathroom, yeah.
All right. That would have been where you brushed your teeth
But yeah,
and washed up?
but I did. That's where I would do those things, but I didn't do them.
You didn't
those
do
things.
either of those
No. Soon after,
Within 5 minutes or so? 10 minutes?
I started to doze off.
And you believe that you dozed off about 15 minutes later, which would have made it about 12:35?
Somewhere around there.
All right. So in terms of the timing of this, assuming that he opened the bedroom door after you already fell asleep, if you're getting home upstairs to your bedroom around 12:20 and it takes you 15 minutes to go to bed, and that's around 12:35, then sometime after
Sorry.
you're asleep, after 12, assuming that he opened the bedroom door after you already fell asleep, if you're getting home upstairs to your bedroom around 12:20 and it takes you 15 minutes to go to bed, and that's around 12:35, then sometime after you're asleep, after 12:35, that's when Colin opens the bedroom door, correct?
I don't remember exactly.
So it's just
And
sort of a
you know-
real practical approach, saying, getting him to minute by minute try to figure out exactly how long it would have taken to push the time out. So maybe it's more like after 12:35. It still would have been difficult for them to get Colin home fast enough. But this is one of the approaches the defense made was, look, if you really dig deep into exactly what the parents are saying, you can kind of push that timeline out farther. It probably wasn't 12:35. They also sort of went for the approach that this really isn't all that believable, this whole stopping by the room. Let me play this and then kind of tell you the approach.
Like most teenagers, Colin drank alcohol with his buddies, correct?
Correct.
And I think the point of the defense was, it doesn't seem very likely that a teenager who's been out drinking is going to open up, voluntarily wake up his parents to let them know that he's coming in, that he's coming in late. That all seems a little odd. Most teenagers wouldn't do that. The mother, however, did explain specifically that it was the way they worked things, that was what she required of them, and that she wanted them to do that just so she wouldn't worry. So that's kind of how the testimony came in. They also talked about a fight that Karen Reed's team believed and probably Karen Reed had some information or something about this, that there was some kind of fight between John O'Keefe and one of the Albert children, and they believed it was Colin. And so it all started with what seems kind of disconnected, but connects up.
Can you explain for the jury who or what is Nebercracker?
What is Nebercracker?
Yes.
Like the
Okay,
character?
Jeopardy there. What
That's
is
what I'm asking.
Nebercracker?
It's a character in a cartoon called Monster House.
And would you agree with me that Nebercracker in the movie Monster House was this kind of old curmudgeon who didn't want anybody on his lawn, correct?
The character, yes.
He was the get off my lawn guy, correct?
In the movie, yeah.
What was your nickname and your wife Julie's nickname for John O'Keefe?
Mr. Nebercracker.
All right.
I believe so.
And this whole nickname started because of a conflict that Colin Albert had with John O'Keefe.
Not correct.
John O'Keefe complained to you about things that Colin was doing.
Not correct.
He would tell you that Colin used to throw beer cans or beer bottles in his bushes, correct?
Objection, Your Honor.
So you can answer that. What's your answer to that?
That is not correct.
John O'Keefe told you that Colin used to flip him off, correct?
Not correct.
And say F you to him.
Never.
Colin used to cut through his yard.
Nope, that was Dylan.
So think about when the judge goes to rule on this next time, because in every situation here, the answer was that's not correct. That's not correct. So there wasn't any actual evidence to support the question. They didn't present evidence at trial to support this. So I think the judge may be asked next time, may be told, look, there was no evidence that he threw beer cans. There was no evidence that John said he flipped him off, et cetera, et cetera. So we want you, judge, to keep this entire line of questioning out, the entire line of questioning about Colin Albert, because we don't believe there was any intent. And that was one of the factors, as you saw in the law that we took a look at. So the dad goes ahead to explain more about what actually happened with that Nebercracker incident. So here's what the dad had to say about it.
It's a joke. It's so my son Dylan, who is my littlest one, he was cutting across John's lawn one day, coming home from the school, walking. This is before John had a fence that went this way. Like on.
Double sorry.
What was sort of the origination of that?
It's a joke. It's so my son Dylan, who is my littlest one, he was cutting across John's lawn one day, coming home from the school, walking. This is before John had a fence that went this way, like on Pleasant Street. So it would just cut off like a couple of minutes. He ran across John's lawn one day. This is my littlest son, who I don't even know at the time. He might have been like 9, 10. I'm not sure exactly how old he was. And John yelled something to him, "Hey, kid, get off my lawn." So John was just making a joke. So Dylan got scared. He ran home and told my wife, Julie, and then Julie in turn called, called Jen maybe and said, "Hey, John just yelled at Dylan." And I think Jen reached out to John, and John felt terrible. And John came down the street. John asked what kind of candy Dylan liked, and John brought Dylan a bag of candy and just said, "Hey, I was just kidding." It was just, so from that point on, we called him Mr. Nebercracker, and it was a joke between John. John thought it was funny.
And that was the explanation that actually came into evidence. So I would expect on trial number 2 that the prosecution is going to put this in front of the judge and say, nobody came to trial and said that this was actually a dispute between Colin and John O'Keefe. And since John isn't there to testify and Karen, I would assume, would elect not to testify, there may not be evidence of that or testimony about that. So I think that the next time, the next trial, the reason this matters is because I think it might come out differently next time, because the judge is going to be asking the question, was there support for this at trial? And the people around Colin did not agree with this. The people around Colin, including his mom and dad, said that's not the way it happened, and there was another child. So I think we'll wait and see, but I do think it might be a little bit different next time around. So I need to say some thank yous. Annie K, member for a month, delighted to have it. She doesn't think the Commonwealth will try this again. I do, because I think everybody's got their dander up. I've been a mediator for many years now, and one of the things I do is try to help people read cases without having to go to trial. And once people, and lawyers are super bad about this, they'll get emotionally invested in it. And we lawyers pride ourselves on not being emotional, but we are, and they'll get emotionally involved in it. And then it's really hard to back down. And so that's one of my roles, is trying to get people to back down, trying to get people to move from their first really solid position. So, but because everybody's pretty dug in, I think they'll try it again, but I don't think they'll try it a third time. I'll put it that way. We'll see. We'll see. I respect your opinion. It was Amy K. My apologies. I respect your opinion, because it is, I think, a mistake to retry it. I don't think it will be a different result. That's why I think it is a mistake to spend the money and to retry it. Graciela, thank you. And Anna Lee, I appreciate your super sticker very much, both of you. Lynn is asking me a question. The handling of objections seems so unfair. Sustained, it implies the jury should disregard, but the reason could be asked and answered. It is true. Lynn is pointing out a point that not in every court, and not in this court, did they state the grounds for their objections. Usually during trial, one side will stand up and say the root of their objection. So they don't just say objection, they say objection, hearsay, objection, form, whatever the right thing would be. And that didn't happen here, which means that the judge was kind of mind reading, guessing whatever it was that would be the reason. I think she probably does that so as not to prejudice the jury with what the objection would be. But it was sometimes a little bit hard to follow. It was different from what I normally expect. So also welcome to Hello, who is a new member. All right. So another approach that the defense had to mounting this third-party culprit defense related to Colin Albert was talking about his fights with other people. So, and I'm going to take you through them. Let's
taken on
start here.
That photo was taken on February 26, 2022.
Yes,
At the place called, I think it's called Finway Johnny's, right?
correct.
Okay. Are you in that photograph?
Yes,
Which person are you?
in the middle.
Just a second. And about what time of day was it? That's you in the middle?
Correct.
Okay. About what time of day was this taken?
Not sure.
Was it at an event of some sort, or just you were at a bar?
Just at a bar.
Okay. I want you to take a look at your right hand. Can you see from there clearly your right hand?
Yes,
What do you notice about your right hand?
it's cut up.
Your knuckles are injured, correct?
Correct.
How'd you get those injuries, Mr. Albert? We can pull the lights up.
I was at a party, a house party my senior year, and I remember it being icy out, and it was kind of like a steep hill of a driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I had tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
What'd you have in your left hand?
If I remember, it was either my phone or a beverage.
So, according to you, you fell on ice and injured your knuckles, as we just saw in that photograph, right across the top of your knuckles.
Correct.
Okay. So you fell onto, what, pavement, asphalt?
Yes.
And you braced yourself when you fell, your entire body weight, by putting your right hand down in a fist, and you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
Objection, Your Honor.
Sustained.
You indicated on
So that makes me laugh every time I hear it. Seriously? Which is not an actual question that he could ask. But it did seem pretty preposterous. And one of the defense approaches was to say, Colin Albert is the kind of person who has lots of fights. There have been fights in his past or in his history. Let me turn that off. My bad. Okay, so he's had these before, and he might have had this with John O'Keefe. He might have had a fight with John O'Keefe. They played 2 videos, which I won't repeat here because they have a lot of cussing, which makes YouTube crazy. But I think it's fair to say they were alarming. And one even ended with Colin saying bang, bang, which I'm not sure exactly what that meant, but it was somewhat threatening. So he played then a second video, Jackson, Karen Reed's lawyer did, where Colin Albert was talking to this same group of people. These were apparently videos he sent to some rival group in 10th grade. So he was very young at the time.
Cross-examination, you've never been in a fight,
No.
indicating that you have no violent tendencies and no violent proclivities, correct?
Nope.
What were you saying on that video?
That I would beat them up.
So when you said, I will pick you up and I will beat your ass, was that a friendly invitation?
No.
Were you threatening these advantage boys, guys, whoever they are?
Yeah, kinda.
Were you
Kinda.
threatening them with violence?
Kinda, yeah.
So you're threatening them yet again, a
I
second time.
appreciate that honesty.
Yeah.
What does pull up mean?
Like, come by.
Yeah, meaning get over here, right?
Yep.
Because when you do, I'm gonna pick you up, right?
I omitted a word.
Yeah.
Meaning I'm gonna fight you and I'm gonna put you down, correct?
Correct.
That was your threat to them.
Correct.
Would you like?
And apparently, Colin Albert had shown up at a proceeding where he was being asked questions. I don't know exactly what it was, probably some kind of grand jury or deposition, some kind of hearing where he was actually testifying. And then apparently had bruises or scratches on his knuckles that time as well. Here's how that testimony came
July
out.
27th, 2023. Do you remember being at another hearing?
Yes.
You remember being questioned by some attorneys?
Yes.
Do you remember the question about the condition of your fist? Literally at the hearing?
Yeah.
You were asked questions by the questioner about the condition, the physical condition of your fist, weren't you?
Correct.
And you claimed at that time, well, let me back up for a second and ask a different question. They were asking because you had open injuries on your right knuckles yet again, didn't you?
Correct.
You said, I must have been hitting a heavy bag, right?
Yeah.
So here's the issue that the judge is going to have to consider. Having a fight with other people, threatening other people in 10th grade, that's not the same thing as having a fight with John O'Keefe. And so there wasn't really direct evidence of animosity between Colin and John O'Keefe. Karen may have known about it, but since she did not testify, nothing actually came into evidence, at least not that I recall, that suggested Colin and John O'Keefe were battling. So the judge is going to have to go in there and weigh that statute that I showed you earlier, or the rule or procedure that I showed you earlier, and the notes. She's going to have to ask herself, okay, was the evidence sufficient that it should come in? She's going to have to keep in mind that the notes tell her that it's a due process right, and this has to be admitted a second time if, in fact, it fits all the criteria. So she's going to have to make that decision. She may have already made it. I didn't hear a ruling at trial, but one thing that was completely obvious was that the defense didn't mention Colin Albert in the closing. And it was pretty different from the way they treated Brian Higgins, because with Brian Higgins, they talked about him a great deal. But oddly enough, the only side that mentioned Colin Albert in closing was the prosecution. So I don't know if the defense is concluding that they didn't feel that was strong enough that they wanted to focus on Brian Higgins, if it just didn't make the cut because he only had an hour. I don't know what the reason for that was. Here's what was said about Colin Albert in the closing arguments, and it was in the prosecutions, not the defense. Oh.
And essentially you came in, went to bed, so do you know what time your son came home that night?
Yes.
Oh, shoot. Let's see. Surely I can find it pretty. Oh, yep, there we go. Nope. Oh, I know what it is. It's another video. Okay, here we go.
From the waterfall video, you have Ms. McCabe Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. You have the testimony, recall, and you have text messages in regard to Colin Albert when he gets picked up from Colin.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. We have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed.
So the prosecution argued, without the defense saying anything about Colin at all, that Colin wasn't there, that he'd already left, that there was evidence in terms of the text messages between Colin and Allie McCabe, who picked him up, and that his parents said the same thing about the timing that he got home. So saying, okay, what you have in front of you, jury, is evidence that he was gone and not available to have harmed him. The prosecution also mentioned a comment that Karen Reed had made in custody. This was the only sort of comment that went back to the original defense argument that it might have been Colin Albert.
You have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked.
I personally didn't see how that really helped the prosecution, but they did mention, they put it in evidence and then mentioned it again in closing. So I want to turn now to our timeline and just sort of go through it and see what the evidence was that was presented at trial related to Colin Albert. And then we'll talk a little bit more about analyzing it, understanding more about what may happen the second trial, that kind of thing. So, and I do want to put up Bill Smith's comment. Do you think the defense will stress the timeline, like yours with a graphic, more if there's a second trial? It seems like the defense wasn't concerned with the timeline at all, and Bill thinks that it's a mistake. I think timelines are hugely important. I think a lot of people learn visually, and they learn by seeing things in sequence, especially when you have a case like this where there are so many different components coming together, because this is a situation where it's not heavy. There are troopers, there is DNA evidence, but the number of witnesses, just witnesses, is extremely large because it was a party and they interviewed or talked to and then brought to trial all of the people who were at the party, the people who were just friends, the people who were family. So it kind of spread out. There were a lot of different people. So I think that's really helpful. It is difficult to use a timeline during the course of the trial because it's not evidence, it's a demonstrative aid. I think there are ways to do it, but I agree with you, Bill, that it'd be a great idea for them to focus on that, because I think they have some strong arguments about the timing and where it was impossible for certain things to happen or possible for certain things to happen that the prosecution is assuming did not happen. I also want to mention Isagel's comment that at some point I got paranoid and thought no one was reliable. I found myself about every witness like she must be making something up out of his or her mind. Definitely there's something. I completely agree with you. And I think that's exactly what the problem is with losing credibility. That was exactly why I thought that inverted video of the car being pulled into the Sally Port was such an enormous problem, because it's all about credibility. When one side loses credibility with the jury, when the jury says, I don't know if I can really believe what you have to say to me anymore, or both sides do, but particularly if one side loses that credibility, that means the jury is no longer with them. The jury is no longer believing what the witnesses come in and say. Instead, they're being exactly like what you're talking about. They're being very skeptical and saying, I really don't know if I can trust you or not. I think that's definitely a problem. And Jadzia, so glad you've been a member for 4 months. Thank you. All right, so let's dive back over. I'm going to pull up the timeline. I've got I've got to stop sharing one screen and then add another in. Give me just a second. Okay. Stop. There we go. And I'm going to share a different screen so y'all can see the timeline. And let me say again, this is a timeline that I am super proud of because it's not just my timeline. The members helped me. We had a special session with some of the members of the channel. What's a member? It's a way of financially supporting the channel. But in this case, also of helping me actually prepare materials for you to take a look at. We had so many people volunteer. We all met together. There were a lot of people who added and contributed. And then a special group calling themselves the Paralegals came up, each assigned a different day, and they gave me additional help sort of beefing this up and making sure that the times were in. Any mistakes are mine because I guarantee you they gave me all kinds of information, which I tried to include. So let's take a look through this, and let's look specifically. Colin Albert is kind of an orangey color, so let me zip through and find him. So there he is. So this is the night that John O'Keefe was out drinking with Karen Reed and other people. He hasn't been hit by a car. He has not been left in the front yard by people from inside the house. Nothing has happened to John O'Keefe yet. It's 10:45, 11 o'clock. Brian Albert Jr. says right then is when Colin Albert arrives at Brian and Nicole Albert's home that's 34 Fairview for a birthday celebration with Brian Jr. Now, Colin says roughly the same thing, that he arrived 10:30 or 11. So they put him there, getting there sometime at or before 11 o'clock in the evening. And then he stays. His mother is out with the people who are drinking at the Waterfall Bar, which would include John O'Keefe and Karen Reed, although they didn't even get there till about 11. So I don't know if they overlapped or not. But Julie left the Waterfall Bar early because she had a headache. Now, her husband was still there, and he left about an hour later when the Waterfall Bar closed. We'll see that in just a second. At 11:54 p.m., Colin texted his friend, Allie McCabe, and asked her if she would give him a ride home. He was at 34 Fairview with his cousin and said, hey, would you mind giving me a ride home? I need to get home. At 12:05 to 12, and may I say too, she texted him back 1 minute later. I should have that in here, but she did text him back. And then at 12:05 to 12:10, Chris Albert initially said that he personally arrived home at that point. He did not go to his brother Brian Albert's home for the party. But between 12:10, I say 12:10 and 12:10, which is a pretty tight window. I would say I got one of those wrong. His wife, Julie, said, yeah, he came home around 12:10. The Waterfall Bar technically closed at 12, but a number of people left 10 or so minutes later. You can see Jim McCabe left about 12:08. You can see some other people. So roughly speaking, he'd left about the time that the bar was closing. At 12:10, Allie McCabe texted Colin here because she had actually come and arrived at 34 Fairview to pick him up. So he had asked her, would you mind giving me a ride? And she arrived and said, I'm here. Come on out. I'm ready to take you home. She said she did not yet see her mother is Jennifer McCabe. Her dad is Matt McCabe. And they were about to arrive at the party at 34 Fairview. But she said that she didn't see their car. The suggestion of that is it's going to be a few more minutes till they arrive. They aren't there yet, and Colin leaves early. Colin does come out after a, quote, few minutes. So it's a little bit of time for him to get out. And Colin says he left at 12:10 a.m., so it may have been a little bit later than that. Now, a contradiction here at the Waterfall Bar video shows Chris Albert leaving the bar at 12:13. Meaning not at 12:10, which is when he thought he got home. So some minutes of difference there. Then from between 12:15 and 12:30, Chris Albert said that Colin arrived home between 12:15 and 12:30. And Julie says Chris arrived home about 12:20, which would probably fit with the Waterfall Bar video, and came straight to bed. They both say it was a total rush, no brushing teeth, no nothing, just bam, into bed. And then she says Colin arrived home shortly before 12:30. Colin says he arrived home maybe 12:20. So you can sort of see where the testimony came out and draw your own conclusions about it. At 12:30, Allie McCabe, the daughter of Jennifer, says she arrived home after picking up Colin and taking him home. There's contradiction to that because the Life 360 app on her phone suggests she's at a school about an hour later. That doesn't mean she didn't come home, but maybe she went back out again. Let me see. That may be the end of our Colin Albert. Oh, here we go. Something else. Yeah, here it is. 1:30 a.m. The Life 360 installed on Jennifer McCabe's phone, which law enforcement got, showed that Allie McCabe drove around and did not arrive home until about 1:30. So that was what was shown, was that she didn't drive around. I think that covers it. Okay, so let's pull that out. And we can talk some more. And so what I'm going to do now is talk a little bit about sort of what will happen next with this, but I want to go pretty much soon to questions. So go ahead and be thinking of your questions. If you put them in the chat, if you wouldn't mind, put question marks at the beginning. It makes it a lot easier for me to spot them. I have a better chance of seeing your question there. So let's take a look at what some of the people have asked. Barbara is saying she thinks she's in the cart ride. It was put in Karen's head that she hit him, and that's why she may have asked it on the screen. In the car ride. I was wondering, the cart ride, if there's some piece of evidence I've missed. Yeah, Barbara. And some people think that maybe that's how she came up with that. That may be. Barbara is a new member. Welcome, Barbara. And thank you very much, both for your super chat and for being a new member. I'm glad to have it. Shane 68 wants to know, can the state replace her expert witness that botched the accident reconstruction testimony? And the answer is, I think, yes. I don't think they're tied to Trooper Paul. The problem is that he is the one who actually did the measurements and all that. They can't completely drop Trooper Paul because of the fact that he has those measurements and that information. They have to get it into evidence. But could they hire another reconstruction expert? I think they could. I think they could hire somebody and bring that person in and ask them to do a more formal reconstruction, maybe even with some modeling that would be on the computer or something to demonstrate how they believe the accident happened. I thought that was a huge weakness in the prosecution case because I felt like at the end of the case, I still did not understand how the accident happened. I didn't understand how the car worked. I know they said she backed up for 60 feet at 24 miles an hour. I got that. But it was unclear to me. This 3-point turn apparently was earlier, and this was just straight backing up. So why is she 60 feet away from him and he's all the way at the end and he's pointing in the? I just didn't get it. So I think that there was a lot that they really needed to do that I don't think they satisfactorily did. So will that change? One of the things about trying the case over is that a lot of things may change. A lot will be the same. The witnesses are tied into what they said and they can be cross-examined. If they say something different, then whichever side can pull out the transcript and say, well, isn't it true that last time you said X and now you're saying Y? So, wow, what's the deal here? So they definitely can be cross-examined, but it is a new trial and some things will change. There will definitely be some things that will change. All right. So Dreamer Thinker is wondering about a FOIA to get all the trial transcripts. So I will tell you this. You probably could, but you would have to pay the court reporter for the trial transcript, I think. That is so expensive. You would not even begin to believe how expensive that is. Sometimes it can cost, you're going to think I'm making this up. I'm not making this up. Tens of thousands of dollars to get the transcript of a trial, particularly a really long one like this. It could be substantially more than that. So thank you for your comment about the timeline. I think it would be too expensive to try to get that. It definitely would be helpful. It would be useful for everybody, but unbelievably pricey unless that just gets released somehow. It is really a shame because I think it would be helpful for people to have that. Barbara, welcome. Got another new member. We are so glad to have you. And Helen, thank you for the super chat. I appreciate it. And Cutley has a question. Cutley wants to know, will the prosecution have to recall the medical examiner in the next trial, even though her opinion on the injuries was inconclusive? They don't have to. They certainly could elect not to end with her, because it was hardly the bang that they went out with, because it was so unclear. She didn't side with the prosecution really about anything, not even that it was a car wreck. There was nothing she agreed with that of the big things they wanted to say. She wouldn't go with them on. So they have to call her? They probably do have to call her, because again, she examined the body and she has information that they probably are going to need to get into trial, but they don't have to call her last or make her kind of a showpiece. They might not need her facts. Maybe they could do without her. Certainly it would be a possibility for the defense to call her, but I don't think they would, because they have their own witness who says the opposite. So why bother to put in somebody who says, I don't know which way it goes? It doesn't really help, I don't think, in that case. So let me flip over to the chat and see what the questions are over here. Trying to figure out when exactly I said that and to back up long enough to find out. Okay, well, I'm going to stop right here. I often don't go all the way back, but hopefully I did this time. Okay. So I see, I see Hopester asking me, in a retrial, is it always the same judge? It doesn't have to be, Hopester. Let me give you an example for let's say that the judge retires or dies, something happens and the judge isn't available to do the trial. Of course, they're going to bring somebody else in, but usually the same judge would retry the case. And in this particular situation, that's what's going to happen. This particular judge is planning to retry the case and to be the one. It makes sense because this judge already knows the case, already knows the facts, has already made rulings. It will be a lot more efficient for her to try it than for someone new to come in. So does it have to be? No, but typically it would be in most cases. Becky B, do you think, based on the evidence, that Karen hit him with the car? So having thought about it, I've decided it would be best for me not to say, although I had said something earlier. I think it would be better for me not to, because this is going to be tried again. And one of the things I like to do is remain neutral. It was very comforting to me that people were surprised at what I thought. That means that I did a really good job of being neutral so that people can make their own decisions. I try to show you what the facts are, how that fits with the law, and not just give you my thoughts about everything. I try to let you make your own conclusions. So that's just my philosophy. Abby PJ wants to know, did Karen Reed get her back? I don't know what that means. Sorry, Abby, maybe a little more context would help me. Okay, and let's see, looking for those question marks at the beginning. Dawn asking me, neighbor squabbles can get pretty nasty and we don't hear about them leading to murder very often. Is this something that happens more than we might think? I felt John was being harassed by Colin. So Dawn, I don't know that there are statistics that are kept on how often neighbor squabbles end up with some kind of crime. Certainly you see some of those things reported in the news. You see that sometimes that will happen. I think in this particular case, the defense did not have a lot of evidence to support their allegations. I'm guessing their information came from Karen having talked to John. And so maybe next time they'll find a witness. The parents of Colin Albert did not support that. They said Colin Albert didn't have a dispute with John O'Keefe. So that they'll have to come up with, Karen's team will have to come up with a way to get that into evidence, to get somebody to say that there was this dispute. Okay, there's Abby. Did Karen Reed get her car back? Okay. Did Karen Reed get her back? I wasn't sure. Did Karen Reed get her car back? Probably not. Often the person does not get their car back for a really long time. It's kind of a poor system, to be honest, because that car just sits there. It's a waste, but I don't know for sure in this particular case if she did or didn't. What about Proctor's testimony? He comes back to testify. Sherry asks a very good question. I think the chances are that he would come back to testify, and here's why. It's what the defense said this time, which is even if the prosecution doesn't bring him, we're going to. So I think that they'll play a game of chicken and the prosecution will have to decide Do they want to bring Trooper Proctor? In this case, it's going to be even harder for the prosecution to bring Proctor this time than it was last, because now we already know there's information that he has been relieved of his duty with the prosecutor's office with the state police. He's no longer doing that duty. We know that he's under investigation by the federal government. We don't know the result of that yet, but those things will make it more difficult for him to come. Yet, he was the lead investigator. And the defense is going to want to get in those text messages he wrote about Karen Reed. They are central to the defense theory about Karen Reed being set up and about why the investigation was so poor. So Scooter wants to know, how do you think the defense might change their strategy in a retrial? And that's a really hard question, Scooter. It's a good question. It's going to be important for them to recreate the trial. That if they try the exact same case, it's often said by lawyers that if you try the same case, you lose. You have to make the case new and different. But they did such a good job. Their tendency will be to go back to what they did before. So I don't know what their new strategies or techniques or strategies, let me sit with that, will be. But I think they will have to rethink things, and there will be some changes. There will be some things they'll have to do differently. I think one thing that will make a difference is talking to the jurors. Apparently, I did see that in Massachusetts, the parties are not supposed to approach the jurors and try to talk, which means that they will be listening closely to what the jurors say. And as I say again, if anybody knows a juror, I would love to interview them. So please connect them with me, because I would love to hear what they have to say, what they thought about the trial, what their reaction was to the evidence that was presented. I'd just be so curious what their thinking was on that. Okay, let me head back over here and thank you. Asagal, I appreciate that. She's talking about my husband who passed just not quite 2 months ago. So I really appreciate that. And I have felt so much comfort from the channel. I can't tell you how many nice, kind things that people have said. And I got cards and gifts. It was just amazing. I really felt supported and cared for. And I really can't even begin to say how much I appreciated that. It meant a great deal. All right, so Bill Smith wants to know, does anyone know if Allie has the same car? I wonder if there was any damage repaired. I don't know if she does or not. It certainly, the passage of time, they may well have repaired it and no one looked. That's part of what Karen Reed's team's complaint was. If you don't go looking for evidence right when something happens and you wait years and years, by then information's lost. I don't know if anyone took a look at that. I don't believe anyone has suggested Allie herself had anything to do with John O'Keefe's death, but I imagine Bill is referring to the fact that she was out at 1:30, even though she said she was at home. That app that was on Jennifer McCabe's phone suggests Allie wasn't at home, even though she said she was out at the school. What are the chances? Of course, they're that she's a teenager and was, out partying and didn't want her mother to know, so she said she was at home. But those are all important things when it comes to an investigation like this. Sharon Green, do you think Karen Reed is safe living in her home? I certainly hope so. I don't know of any threats against her that I've heard about, but I certainly hope so. I guess I'll have to stop with that. Brian, will the defense experts get to testify with the scope of questions being expanded from the original trial? No more discovery issue. What a great question, Brian. That is a great question. The answer is yes, I think so, because part of what they were limited on was the fact that there hadn't been disclosure about this in advance, particularly Dr. Marie Russell, who talked about the dog bites. And she also had an opinion about the injuries on John O'Keefe not being consistent with a car wreck, which was also what another witness said for the defense. And so I think that, for example, might come in this time because there is more time. I don't see why there would be some restriction on that if the only objection was not her qualifications, but just that it wasn't disclosed in time. So that's a great question. All right, looking for those question marks at the beginning because that's my only hope of finding these in here. Michelle wants to know, would love to hear your legal opinion regarding the trial. I'm going to hold off on that until the retrial, since that this is not the normal trial. At the normal trial, you have a final verdict and it's over. And here we had a hung jury. So this is, according to both sides, going to be retried. Will there be something that happens in the middle? Possibly, that keeps it from being tried. But as of right now, everybody's saying we're going forward. We will try this. All right. Pink Door Katie asking me, do you think any ethical lines were crossed with the defense accusing people so openly, both in and out of the court? Certainly inside the court, Pink Door Katie, you are allowed to do that. We looked at those rules at the beginning and the notes that were with them, and there's actually a due process right to charge other people with the crime, to point the finger at somebody else if you're the defendant and say, I didn't do it, that person did. So they had a lot of due process rights. Now, comments made outside the court are more questionable. I won't get into that because that would depend a lot on, for example, Massachusetts law. So I won't get into that. But that will be taking those statements that were made inside the courtroom. And I mean the testimony, all the arguments, the questions, because often a question is kind of a statement. When you say, isn't it true that you had an argument with John O'Keefe? And the answer is no. Then the only statement there was the question. Do you see what I'm saying? So as far as whether or not that will come in again, I think we'll find out. I think that there will be likely there would be some kind of motion to the judge trying to exclude Colin Albert and trying to say that the information about Colin Albert wasn't connected enough, doesn't meet the standard under the rule in Massachusetts. We'll see what happens with that argument. I don't think that, certainly in court, there was a line crossed because the judge allowed it in and because it was a due process right for Karen Reed to be able to talk about that. Okay, let's see. Looking for those question marks, looking for those definite question marks. There we go. Michael, could the defense go to the custodian of records at Ring and get more Ring doorbell evidence? I think so. I don't see why not. I believe they could. They'd have to fill out the FOIA. Now, remember, it can be a double-edged sword. You never know what you're going to find when you go get more evidence, but I would think they would be able to get more. I don't know why they wouldn't have done it before if they wanted to. I mean, they had a couple of years to investigate and to look into this and didn't. So we'll see. I wonder, too, if there will be anything more to come out of the federal investigation or if we're done with all of the information from that. It could be that's it. We now know the full extent of it, or it could be that there are more shoes to drop, put it that way. Okay, looking for the question mark, sorry. Getting distracted reading while I'm doing this. Rosie asking me, have they ruled out a third option, an accident? Imagine it wasn't Karen or the others. Maybe he slipped and fell on the ice, hit his head, and was too drunk to get up and froze to death. And Rosie is from Canada and says she's had bad falls on ice before. And you don't have to be Canadian to imagine slipping on ice. So I get what you're saying. And she's got special experience with that. You know, it's certainly an option. It isn't the approach at all that Karen Reed's team took. They went all in on she was framed and that there was a failure to investigate properly through Trooper Proctor. So that was their approach this time. It wasn't just that he slipped and hit his head on the ice. And their experts have now come in and said, we don't know how he got hurt, but it wasn't a car accident. But we don't know. So they haven't ruled out it being an accidental fall. Nobody has sort of explored that or suggested that. It's an interesting question. Okay, looking for those question marks at the beginning. There we go. Okay, M&T. Have you seen the computer animation on YouTube? I have seen a computer animation. To be admissible at trial, it would probably have to have a lot of science behind it. I don't know exactly what the underpinnings are, but it was really interesting to see. I definitely enjoyed that. Amy K asking, no, please, to Bev, same outcome if so. So Amy K is asking, if the case went back to the same judge, to Judge Beverly Cannoni, would the same outcome happen? I think the chances are that the same outcome will happen. But the reason I think that is because the populace is deeply divided about this case, not because of the judge. I don't think in the end, she kept out any of the significant evidence that the defense wanted in. And that's probably the most important way a judge can change the result of a case. But for the most part, she let that in. She let them argue Colin Albert. She let them argue Brian Higgins, or at least present evidence related to that. And so I think she, in the end, let them have most of what they wanted. I would expect that to happen again. Granted, I don't think she seemed like a fan of the defense. She definitely did not. But I don't think she is going to change the outcome. I think if the outcome's the same, it's going to be because people really disagree fundamentally on this case. People really, really disagree over whether Karen Reed hit John O'Keefe with her car. And they really disagree over whether that was proven beyond a reasonable doubt. I think that's the reason that it will be, that there will be a similar result. And that I do think there would be a similar result again. Oh, that's interesting. Laura Lee Annie is saying, well, so something Lally got right was juror picks, picked correctly on the jury. I do think when you look around, take a look at the chats that happened if you watch the live stream of the trial, and you'll take a look. 70% of the people, that's just my guess, 70% are talking about how Karen Reed is innocent. She's being framed. This wasn't a car wreck. 30% are saying she's clearly guilty. She did this. It was obviously a car wreck. What's wrong with y'all? So it just seems like there are really polarized views on this. And the jury seemed to reflect what I perceive as pretty polarized views among people generally. I think it came out that way. Oh, thank you, Melody. I appreciate that. And I'm glad you've been a member for 3 months. So we'll take a couple more questions. Let's see. Uncle Jerkle. I can't quite read this. It says the only pause for the car accident is where she was before she went to Jen's house. Did she go to 34 Fairview in the morning? That was one of the arguments that the prosecution suggested, that there was a gap in time. And we see that on our timeline. I won't pull it up right now, but we see that gap when there's a period of time she's supposed to be, she's driving by, she's actually captured on camera right outside the library, and she should have gotten to Jennifer McCabe's at such and such a time, and it takes her longer than that. Now, one obvious thing, maybe she pulls to the side of the road, and because there's all this talk about how she's texting and calling everybody. So maybe she pulled to the side of the road to text and call people. But the prosecution said maybe what she did was drive by 34 Fairview. So when she was then with Jennifer McCabe and Carrie Roberts, and they were pulling up to 34 Fairview, and she saw John's body before they did and began screaming to get out of the car. There he is. They say the reason for that was because she stopped by 34 Fairview. That does somewhat undermine their argument, though, that this was intentional, because that would suggest she didn't know about it until she, that morning, drove by and was like, wow, look, he's lying there. Maybe she formed the intent that night, forgot about it because she was drunk. Maybe that's her argument, but it does seem a little contradictory right there. All right, last question or so. Jennifer, should there be a gag order, change of venue, and sequester jury in the next trial? I don't think it'll make a difference, Jennifer. As far as a gag order, I guess you mean like the lawyers coming outside of the courthouse and talking. I certainly would not agree that there should be a gag order between now and the trial. Sometimes judges do put a gag order in place during a trial, so that might be something the judge would do. She didn't this time, and there were conversations even Karen Reed had with the media during the middle of the trial. They were always, careful, very careful. She didn't blab or say anything that she shouldn't have, but it was still something that happened. But as far as whether the jury would be sequestered or whether there would be a change of venue, I think, first of all, that there is lots of people know about the case who aren't even in that area. I think you can move just about anywhere in Massachusetts and you're going to find a lot of people who know about the case. Obviously, it won't be to the extent of the local community where clearly they're going to all have heard about the case. It's not that big a community, so it's going to be well known. But I don't think there's pressure by either side to move the case, and certainly not by the defendant. The defendant, I think, realizes how deeply divided the community is and thinks that this is a community that in many ways has supported her in terms of her trial. They've shown up, they're outside protesting. So I don't think that she would particularly want that. Okay, so, well, we will be here tomorrow night at 7 p.m. Eastern. We are going to be looking at Brian Higgins. Be sure to hit the subscribe button. You don't want to miss that. We're going to be looking at the third party culprit argument as it relates to Brian Higgins. Also, if you would hit the like button on your way out, and I will see you tomorrow at 7 p.m. Eastern.